All right. Hey guys, it's Ryan. I'm here joined with Dan Crowe today. Dan's a lawyer out of Yelm. He does local landlord tenant type law, as well as some other types of law, including business. And I guess I'll let him kind of introduce himself. But we want to take a little bit of time to talk today about ejectment versus eviction, and this is something I have personal interest in, and I think it was something that I'm learning more about, and so I know that there's a lot of other investors that probably would like to know a little more about it as well. So this is I think I'll let you take a minute, Dan, and maybe introduce yourself here.
Sure. Thanks, Ryan. I've been an attorney now for almost 20 years. My practice primarily revolves around business, real estate, estate planning, and probate. And during that entire time, I've been working with evictions, mostly doing unlawful detainer work. And so I've watched the changes very closely that have happened over the last couple of years. But my practice primarily involves Pierce County, Thurston County, and Bliss County. So that's what I'm most familiar with.
Okay.
Procedures.
So let me just let me give like a brief rundown without giving a whole lot of information of kind of the situation I found myself in, and then what I thought was maybe the right way to go about it, what was not the right way to do it, or maybe something that we could, if I ever ran into that situation again, maybe what I would do differently or find out. So I purchased a property in September, and the owner of the property owned it for 50 years. And that person ended up going into a senior living situation and had dementia. So the family had power of attorney, and the family wanted to sell the house, help pay for care, maybe other reasons, but they wanted to sell the house, and they reached out to several investors to do so. And I'm the lucky guy that ended up buying it. And so, and with that, there was another occupant in the house, and that occupant had lived there for 30 years. Was a girlfriend of the seller, and that person, knowing that person was in the situation, basically, we found ourselves in a situation where the family didn't want the person there. The person did not own the house, but she's still there. And so now I went through the process of serving them with a 90-day intent to sell, because my intention is to sell the property. And after going through all that and having the free lawyer and everything, I guess it was determined that that was maybe not the right angle, because it's not a normal landlord-tenant type occupant. So maybe, Dan, maybe if you break down kind of the dynamics of that and kind of the particular points that make it so that it would not apply for a normal notice versus what it would do.
Yep. So the difference is in between. There's basically two types of evictions on residential properties. Eviction is kind of a catch-all term that includes unlawful detainer on the one hand and ejectment on the other hand. Ejectment is what we've traditionally used for situations where you've got basically sort of squatters, people who have shown up unannounced without permission, and they just moved in. You've got a vacant property, or maybe you've got something where somebody's just set up a camp or something. And unlawful detainer is what we've used for more traditional types of tenancies, where you just have a tenant who's stopped paying the rent or has, not following the rules, or for whatever reason you were going to evict them in the past. In your case, you're talking about doing an unlawful detainer for somebody who has moved into the house.
Sorry, hey, Eugene, can you mute your mic there?
Sorry.
Yeah, and so with the unlawful detainer,
the unlawful detainer is going to cover the majority of tenancies, and it's what we've always used in the past. And what we've tried to avoid it as much as humanly possible in the past, because it takes longer than what unlawful detainers have taken in the past. But the landscape has changed dramatically over the last couple of years. First, with the governor's moratorium on evictions and some very strict rules for what you could and couldn't do. And then with House Bill 1236, which passed this last summer and really changed the fabric of the Landlord-Tenant Act to a very significant degree. So what you've got, the situation that you're describing, where you have somebody who's been living in the house permissively. She was allowed to move in. She didn't just sort of show up one day and break in the front door and set up shop. She's living there permissively, but she has literally never contributed a single thing She hasn't paid rent. She wasn't taking care of the elderly gentleman you were talking about who was living there. She wasn't paying for utilities. She wasn't mowing the lawn in return for being allowed to live there. I mean, there was nothing. And maybe we thought at the beginning there was, but it turned out there was nothing. This is what we call a tenancy at will. And the courts have now determined that, or not now, but the courts even had previously determined that tenancies at will are not subject to the Residential Landlord Unlawful Detainer, or Residential Landlord Tenant Act. So the unlawful detainer doesn't apply. There's some conflicting case law on that, but that's what they're saying now. So now we have to do the ejectment. And the ejectment is not necessarily worse at present, because right now you give the 90-day notice, but House Bill 1236 created for tenants an absolute right to counsel. So it's just like if you're a criminal defendant. So you show up in court. The way this works practically is you file your unlawful detainer, and it's going to take about 2 weeks or so to get to your show cause hearing, because you have to give notice and get observed and all of that. And then you have to make sure that you're on a docket. So approximately 2 weeks, sometimes a little more, but right in there. And they show up in court, and they'll go through the screening to determine whether or not they get a free attorney. And every single person does, because they're tenants. These aren't wealthy people that we're talking about, so they get assigned an attorney just like you would if you were a criminal defendant. So that attorney will then go turn around and say to the judge, hey, we just screened him, we need to assign him an attorney. And the judge will say, okay, and set it over for 2 weeks. There's nothing you could do to stop that from happening. Trust me, I've argued. All of us have. We've all failed. But because they've got a right to counsel, so they can't immediately turn around and argue your show cause hearing. So 2 weeks later, you're going to show up and say it's a Friday morning, Thurston County calendar. What will happen is about 4 p.m. the day before, on Thursday, you'll get an email saying, I was just assigned to this today, because they'll sit on it for 2 weeks. And then they'll assign it the day before. And it doesn't happen 100% of the time, but it happens the vast majority of the time. So then they show up in court and they say, look, Your Honor, I was just assigned this case last night or yesterday or whatever. I need a continuance because I haven't had a chance to review. And the court, you can argue against that, but the court's going to give them a chance to respond, which is not surprising. I mean, it happens all the time in other cases as well. So the court says, all right, you're going to have another week or another 2 weeks, and you'll get a response. Then you get to argue your show cause hearing, usually, unless there's some other delay, or unless you resolve it some other way beforehand. And pardon my cough, I apologize. So now you're 6 weeks in, and plus all the additional time that you spent. That's the process for the unlawful detainer. And that's the one, like I said, that we've always tried to follow before, because it usually didn't take us that long. They may have a right to counsel. They didn't have a right to counsel before, but they may get free counsel before. But it wasn't this sort of procedural thing where it took us this long to get to the actual show cause hearing. Ejectment, on the other hand, is not statutory by in its definitions. The unlawful detainer statute and all the procedures and the ERPP and the 90-day notices and all of that you do with unlawful detainer, that's all statutory. It's contained right in 5918. It's kind of in the 600s, if you can read those. Those are all the new rules that we have. But ejectment is not. Ejectment is just a process where you're getting rid of somebody who is on the property, either, like I said, prior to on the property without permission, and they just moved in and said, it's mine now. Or a situation, I guess, like what you're talking about, although we did used to do unlawful detainers for those. And what we do with that, we treat it like it's a normal civil lawsuit. So we file a summons and a complaint. We give them 20 days notice to, that they have to respond once we serve them. And then at the end of that, we bring what's called a summary judgment motion. If there's any other kind of motion we can bring, that's great. If they don't respond in that 20 days, on the 21st day or whatever the next court day is, we can go in and ask the court to give us a default judgment on that. And part of that default judgment is going to be writs of ejectment. Writs of ejectment are exactly like writs of restitution for all intents and purposes. There's some slightly different wording on there, and a few things we've swapped out. But basically, it's the same thing. It's an order that tells the sheriff to restore possession of the property to you. So go out and do the actual eviction. So if they don't respond in 20 days, we get them right then. Otherwise, we bring a summary judgment motion. Summary judgment motions, you have to give a lot of notice. You have to give 28 days notice for those. But at the end of that, you have this summary judgment hearing and you're very, very likely to be successful on that. And at that point, you get your writs of ejectment issued. There's no process for doing it at the very beginning of the lawsuit. So, like you have with unlawful detainer, you file your lawsuit and you do this show cause process where you ask for those writs right away. With this, you do your summary judgment motion and you ask for the writs at that point, because that's the end of the case if you win. In unlawful detainer, you could theoretically continue and just sort of convert it to a regular lawsuit and ask for damages or whatever other sort of complaints you got against the tenant. You could ask for judgments and things like that. But most of us don't with unlawful detainer, because why are you going to take a judgment against somebody who can't pay the rent? It's a waste of time. It's a waste of money. You just cut your losses and you walk. If for some reason you were to lose at that show cause hearing, so back to ejectment, if you were to lose at that show cause hearing, mixing up my words, if you were to lose at the summary judgment hearing in ejectment, then you got a full-on lawsuit on your hands, and you're going to have to deal with that however we deal with regular civil lawsuits. You go through a discovery period. Hopefully you get it into some kind of mediation or something, and you can get a resolution. Hopefully you can find a way to solve it before you hit trial, because we're talking about Thurston County, trial in Thurston County could be a year out. It could be more than that. It might be less, but it's going to be a long time. That's the bottom line. I tell all my clients who are getting involved in litigation, this is not going to resolve itself tomorrow. It's not going to resolve itself next month or 6 months from now. If we're actually litigating a case, it's going to take a long time. Hopefully in these cases with the ejectments, they're usually pretty straightforward. In the one that you described, she's probably making some kind of a claim that she's got some sort of community property interest in the property. That's between her and the seller. That's not between you and the seller. So she's going to have to deal with that. She's maybe making some kind of claim that, she's got adverse possessory rights. I don't know. I don't know what she's going to try to claim. I don't think anything's going to fly at summary judgment. Summary judgment, you've got a set of agreed facts, which is she's living in the house and she doesn't own the house, and you've told her to get out. And you've got how the law is going to be applied to that. The facts have to be agreed, because the trier of fact isn't in effect. The trier of fact is the judge, but the judge isn't going to make a determination of fact. The judge is going to make a determination of law at summary judgment. But when you've got facts like you've described, the law is pretty clear in how it should apply to that, and that's that you win and she should be required to leave the house, or the sheriff can help her leave the house if that's what it comes down to.
Well, it's kind of funny because the sheriff just kind of stands there, right? And then and then I have to pay for movers, and I got to pay for storage or whatever, or find a place to store it, all that crap.
Yeah.
And it's not even like it's a tenant or it's, landlord tenant, because they determined it wasn't, right?
So the actual process for executing on those writs of ejectment is exactly the same as if you did it with writs of restitution from an unlawful detainer. Mm-hmm. So the writs will issue. The clerk will actually issue the writs. The writs will issue to the sheriff. The sheriff will get them. You'll have to write a check to the sheriff for their mileage and all their other stuff. It's usually around $100, but it depends on how many actual miles. They actually calculate the miles you write a check for that. The sheriff will then go out to the property and serve the writs on her. If she's not there, I think they just post them to the door. But the sheriff will get her. And then if you're in Thurston County, which is what you're talking about, within about a week or so, you want to contact the sheriff, 5 days, 6 days, something like that, right in there. Contact the sheriff and tell her that she's still in there, assuming she hasn't moved out. Obviously, if she moved out, you're done. But if she hasn't moved out, tell the sheriff she's still there. The sheriff will then set up a date to do the actual physical eviction. So you're going to show up on that day, and the sheriff will show up, and the sheriff will remove her from the house, and then it is kind of on you to do the rest of the stuff. You're going to want to change the locks on the house to start with. Mm-hmm. The sheriff will give her a trespass warning and say she can't come back on the property. I can tell you both in Thurston and Pierce County, sheriffs are not really enforcing those. We had a situation very similar to yours recently where the guys, the lady that was living in there was doing a lot of drugs, and she wasn't in her right mind, and it was a pretty nasty situation. And we got her out, and she promptly moved right back in. Mm-hmm. And the sheriff came out and sort of removed her again, but they won't take her to jail at this point. At some point, she may irritate the judge or irritate the sheriff enough to drag her to jail, but it's going to take a while. So Sheriff will remove, in your case, a sheriff will remove her from the house. You're going to be responsible for emptying that house out. And you got to store her stuff for 30 days. You can store it in the house if you want. That'll set you back another 30 days. You can move it if the house has a garage or something. You can move it all into the garage and store it there while you work on doing whatever renovations you need to do, to fix the house up to sell it or rerent it. Whatever your plans are for that house, you're going to need to get in there and get it emptied out. If you want to move it to a facility that, like a storage unit, or I don't know, some other facility that you've got where you can sort a warehouse or something like that, then yeah, you're going to have to pay to get it actually moved there. And then at the end of 30 days, when she hasn't claimed it, you gotta probably just throw it away. I guess you could auction it off, but he's been living there for 30 years. It's probably not a whole lot of value in anything else you're going to get.
Not expecting a lot there.
eBay her stuff. I don't think you're going to get anything out of it, unfortunately.
So let's talk. So, like, for example, in this one, you have someone who's definitely trying to avoid being served, right?
Yeah.
So let's talk about, like, when you're in a chat, like, okay, how do you get around that? Because every day she avoids. Hang on. It's trying to ask me to. Every day she avoids service. That's just another day that they're delaying. It's delaying when the court date can happen, when I get her out of my house, right?
Yeah. So I'm leaning hard on the process server on this. A lot of it has to be through process server. There are some alternatives to doing that. I'm trying to remember the court rule that they're under, but there's fairly early in the court rules, the CRs. You can serve by mail. You can serve by publication. There are some potential allowances for serving by posting and mail and things like that. But that lengthens the period of time that you have to wait. So we try to avoid doing that if we can. What we have to do, our showing there, is one, that she is not amenable to service. She's avoiding service. In your case, she knows this is coming. She's already been through the unlawful detainer process, and that she got kind of a reprieve on that. But there's no surprise. Our process server's out there banging on the door and leaving notes for her and everything else, trying to get her attention. So she's actively avoiding service. I can go into court and prove that. It's a fairly simple process, and the judge will say, okay, you can serve her by mail because we do have a good address for her. The other option is serving by publication. There's a little more expense to that, but if you serve by publication, you just stick it in the newspaper, and you've seen the legals in newspapers. That's where it goes. Nobody reads those.
I haven't looked at a newspaper in a while.
I read them because I put notices in there. I want to make sure they got my notice right. But nobody else reads them. Every once in a while, I see a tenant, or not a tenant, but I see a client of mine that's passed away, and those the obituaries and the legal notices. So yeah, like I said, you can do that, but you really want to give it every possible effort to try to get her served first.
Yeah, and so how long do you think you give it until you go that route, right?
Yeah, it's not necessarily the amount of time. I guess it's the number of attempts. If your process server has been out there over and over and over, and they're not getting anywhere with it, then it's time to really start, thinking about taking some alternates. I don't know what the answer is in your case. I have to check the process server, but yeah, or if they're going out there fairly consistently and it's been a couple of weeks and you're not getting her, all right, that may be what you have to do.
I have heard that
judges do not like to allow service by mail or publication. They want you to get service. So I do have to be able to go into court and say, look, Your Honor, we really tried. We didn't mess around. We weren't, guy didn't go out there once and knock on the door and then wander off and go get,
Well, and I think you have a track record with this one too, because it happened in the previous service. Like
that's true.
She avoided it like how many times? And I have heard though from the neighbors that if
we did get her, we did get her though.
Yeah, I have heard from the neighbors that if you go pick blackberries on the property or by the road, she'll come out and freak out at you because they're her blackberries. So
I will pass that along to my process server, and you can get a little snack out of it too.
Right. Well, and one question I have with that is the property is like over an acre. There's a second building, detached garage that she's obviously not living in, right? And and she doesn't even own the house or the property or anything. Is there anything that in the law that makes it so I can't go to the property, I can't go in my garage, I can't go in that's not attached to the building that she is sleeping in? Is there anything tied to that?
No, I would treat her, even though she's a tenant at will, I would treat her as a tenant under the Landlord-Tenant Act, and I would post notice that you're going out and everything else. Mm-hmm. The reason for that is that you want to cross your T's and dot your I's, right? Mm-hmm. This is not an area of law where you want to sort of take liberties or mess around or try to find loopholes or anything like that. And I know you're not doing that, but it's not a good look if you just sort of show up unannounced and say, hey, I'm going into my garage over there. Theoretically, you can post notice that you're going to enter the house as well. Mm-hmm. And just treat it like it's a tenancy, because one of the things about the Landlord-Tenant Act is it offers a lot of protection for tenants. So if you get dragged into court and she says, no, he's trespassing, he's coming on my property, he's not allowed to do that. And I say, look, Your Honor, we gave her more notice than than she's allowed to have. A, it's not her property. B, she may be a tenant at will, but we gave her 48 hours notice that we were going to show the property, and we gave her, or that we were going to do maintenance on the property or whatever. And we did all the things that we were supposed to do if she had been a landlord or had been a regular tenant. So she got more protection than she was entitled to.
So
and that makes sense.
So hypothetically, if I served,
I don't want to say this out loud right now. This is your attorney speaking.
No.
So
if you served it,
there's no attorney-client privilege right now. You understand that, right?
Okay. No, I'm completely. If serving a tenant in that situation, that you're going to enter the property, complying with landlord-tenant law, and if just so happened that the process server happened to be there too. And I was just like, well then, I wonder. But no, that's just me talking out loud. But I
don't care how the process server gets her.
Yeah.
Well, that's not true. I don't want to take it to a brick and throw it through the front window. I mean, that's not good.
Right.
But I don't care. You and I were talking earlier. I've had process servers. One guy, he's not doing it anymore, but he used to. He'd have an orange vest and one of those white hard hats. And he'd show up at the door and tell him he was Puget Sound Energy. Puget Sound Energy knocking on the door. And they'd open the door because they thought their power was about to get cut off, and he'd hand them the documents and walk off.
Yeah. Well,
I query whether or not pretending to be Puget Sound Energy is legal.
Yeah, that's
sometimes you don't ask questions. You got them served.
That's a line I wouldn't necessarily cross, but
yeah. I've heard stories of people dressing up like the Domino's pizza guy.
Amazon would be the one.
Amazon,
they don't knock anymore. Yeah. They don't knock anymore. They just set it on your porch. So they just,
it's suspicious that the Amazon guy's knocking.
Right? I think so.
Yeah. So she's a big giant brown van and some brown cargo shorts and a shirt.
So circle back to like our topic. Like if you're looking for maybe circumstances, what are some other ones that maybe someone could look at in ejectment instead of eviction, or some things that you've seen that maybe someone could say, you know what, that sounds like something I've run into, or that sounds, besides just you got the squatter, you got the person that's lived there for 30 years, they think they own it. Is there any other thing that like pops up as like an ejectment makes sense instead of the eviction?
Not off the top of my head, not really. If they're exchanging something in return for being allowed to live there, you've got a much more traditional type of tenancy.
Okay.
And then it's a matter of looking at whether they've got a lease. Are they month to month? What's the status of the lease? Like, what is it expired? Those sorts of things to determine what you can do if you want to remove them from the property. But nothing really stands out for ejectment other than you've got somebody there who either was A, allowed to move in, or B, was not allowed to move in, and now they're there and they refuse to leave. And 90% of the time, if the sheriff shows up out there, they're going to say, this is a civil matter, go deal with it yourself. So then you have to bring an ejectment action. I can't think of another good way for somebody to get on the property. You got the permissive but never did anything to pay for it. You've got the impermissive and of course never did anything. And then you've got permissive but agreed to trade something for the right to live there. And that could be cash in the form of rent. It could be, I don't know what else, landscape services. It could be, there's some cases out there that, actually here's one. They're not considered a tenant if they're an employee in the sense of, like you have an apartment complex and you have a resident manager who gets rent, it's not rent, but gets to sort of live in the manager's unit in return. You might end up having to do an ejectment on that one, but you also don't have the notice requirements.
And then So, with that, we've also talked in the past about like the nuisance or the ways to get to a 3-day instead of having to go
Right.
through the 69, whatever. And
So boy, has that changed. Yeah.
yeah. And so what are the maybe the things that someone could look for and be like, you know what, maybe that was something I should talk to you about.
Okay. The first thing to keep in mind, this is going back to House Bill 1236. The first thing to keep in mind is that you can no longer evict somebody just because you don't want them there. It used to be if somebody was month to month, you could give them 20 days notice before the end of a rental period. And if they weren't gone at the end of that 20 days, you had to evict them. Now you can only remove somebody or terminate their tenancy for cause. You have to have a reason. Those reasons are, there are multiple ones. The 90-day notice that you're talking about is either the owner intends to sell the property or the owner intends to move back into the property. Like if this all of a sudden was a place you needed to live in, then you would use a 90-day. Extensive renovations, you can look that up, I think it's 120 days. But the shorter notice things are generally things that would cause the tenancy to terminate because there's a danger or there's a threat. So waste, nuisance, unlawful use. Those are three things that we look at. If there's a violation of the terms of the lease that they refuse to fix, you have to give them, you still have to give them notice, but you want to have kind of multiple notices. So you start with a 10-day notice to comply or to vacate. And they won't vacate. Hopefully they comply, but if they don't comply, then you can kind of start to move forward. I would say if it's a very minor violation of the terms, be really careful. Be really careful how you want to proceed there, because you don't want the court to see this as like, you're just looking for a reason to evict them because you just don't want them there. Waste, nuisance, and unlawful use. Waste is damage to the property. So they're out there tearing holes in the sheetrock and, I don't know, having the dog go to the bathroom inside and whatever. They're just destroying the property. That's waste. Nuisance is something that creates a threat to the neighboring homes. So giant piles of garbage that might attract rodents. There's a whole list of things, and there's some pretty awful things in there. But things like that, as they're, I had a case a while back where this guy had these big giant burn barrels, and he was burning like plastic and all kinds of stuff. And it was if you remember the fires a couple of years back where the air around here was just orange, it was right in the middle of that. The guy starts having yard fires. That's a problem. So that's nuisance. Unlawful use is where they're using the property unlawfully. They're cooking meth in the kitchen, or they got a brothel going, or they're selling drugs out of the house. I don't know. Things like that are unlawful use. Those all get a 3-day notice. And it's not a notice to stop using it unlawfully or stop getting waste. It's a 3-day notice to quit. Mm-hmm. So, that's.
Do they get a free lawyer? Do they get a free lawyer on those too?
Yeah.
Yeah.
All tenants will get the free lawyer, because all tenants have the right to that. But those things do not invoke the ERPP, the Eviction Resolution Pilot Program that we've got here in Thurston County. We use that if you're evicting somebody because they're not paying the rent. And that's a different set of sort of hoops that we have to jump through. But if they're committing waste on the property, you give them 3-day notice, and at the end of 3 days, if they haven't moved out, then you go ahead and you file your unlawful detainer. It's an unlawful detainer in that case. Okay, and then you move forward with that.
That helps.
With the ERPP, if you're throwing somebody out for not paying the rent, you have to give them a 14-day notice that offers them a reasonable repayment plan. And when they ignore that, then you have to give them a 14-day notice that you want to participate in this ERPP that invokes the Dispute Resolution Center here in Thurston County. And at the end of that 14 days, you get a certificate from the DRC that says that they refuse to participate. And I'm assuming they're ignoring this all the way through. And then with the certificate, then you can bring your lawsuit. Mm-hmm. But you have to have that certificate, or else you'll get thrown right out of court.
All right. So I did serve that one with the ERPP, whatever thingy. Mm-hmm. But yeah, I don't know if we went that route with it, with the certificate yet. I need to look at that.
They had a repayment plan, and they failed to follow the repayment plan.
No, one of them ignored it. The other one of them did that, and then the other one ignored it. Yeah, so that's interesting. Okay, that's good.
It's amazing what people will ignore. Mm-hmm. a lot of people ignore those, and it's like, this is your chance to not get evicted. Why are you ignoring this?
Mm-hmm.
But
Yeah.
they do. And quite frankly, I don't know. This is just my personal opinion. Most people are not paying their rent because they can't pay their rent, not because they don't want to pay the rent. Most people can't, if they're in trouble financially and they can't pay the rent, they can't pay it. So giving them a reasonable repayment plan, I don't understand how that's supposed to work. If your rent's $1,000 a month, and then the offer is, well, you can pay $1,300 a month. If you can't pay $1,000, you can't pay $13.
Oh God,
That's
tell
how
me
math
about it.
works.
Or
So I
if
don't know how
you're,
anybody's going to pay this stuff back. Maybe if you've got somebody who during the governor's moratorium just decided they didn't want to pay the rent, and so they refused.
I have seen that too. I have
I
definitely.
honestly think those are very few and far between.
Mm-hmm.
That's not to say it doesn't happen. I'm sure it did. And I know there was a certain sort of a movement to just sort of not pay the landlord because screw the landlord.
Cancel
But I
rent.
don't think a whole lot of that. I don't think a whole lot of that happened. I think everybody was hurting financially, and people just couldn't pay the rent, and they just didn't. Or maybe a combination of, I can't pay it, but I also don't want to pay it, so I'm not going to even make a payment plan with my landlord.
No consequences.
No, I just don't see how there's consequences now.
Yeah.
And that's the problem, is there weren't for a while and people got used to it, and now there are. I just don't see how it's going to work where you're going to have somebody paying their monthly rent plus a chunk of the back rent that was owed, when the whole reason that there's back rent owed is because they can't pay the monthly rent.
Oh yeah.
They can't magically just make extra money appear out of the sky.
Well, the other part of it is, they gave a lot of aid. They didn't require the aid to go to their housing. They just gave it to them, right? And then you also add to Washington that you have people like this lady or like tenants that they know they're going to get kicked out of a place. They're pissed off maybe at the landlord or the property owner. And now you give them more time in that property that they're pissed off in. You think the place is going to be in better condition or worse condition than when they were first served? Right.
Yeah, I think if you're evicting them, it's going to be in terrible condition no matter how long it takes.
Well, but it's going to be more. The more time they
you
have
can
to
destroy a house.
Up,
you can destroy a house in like an hour.
Yeah, It's just the more time you have, the more time dogs have to do with their business in the house, the more time kids have to, everything. And it just, the sooner you can get them out, the least you can limit the damage a little.
Yeah, in my experience, doing this a long time, you don't limit the damage so much, but you definitely limit the loss of income on the house.
Mm-hmm. Oh yeah.
I mean, you got carrying costs. You got to pay your mortgage. You got to pay whatever your loan was on that. You got to pay that. You're going to have more utilities money that's built up that's going to be stuck to the property. That's a lien on the property. So even if she doesn't pay her water on the way out, you're going to wind up paying it because you got to be able to transfer that property without that lien on there.
Yeah, and you make a few $100 a month in rent, but then you have $30,000-$40,000 in repairs, which I've experienced, right? And it's like, it's
but the tenant, in my experience, the tenant is going to trash the place, whether it takes 3 months or 1 month, and it's going to be the exact same amount of trash. That's just what I found.
Yeah,
take it or leave it. I mean, it's not a statistically significant sampling there. It's not like I've done 50,000 of these. And I can average them over 20 years, but I've done a lot.
Yeah, well, and all of them here take a good amount of time, no matter what. Even before this, they weren't quick compared to some places, right?
Right.
Yeah.
I mean, each state has its own landlord-tenant act. There's no uniform landlord-tenant act like we have a uniform commercial code or something like that. So some states it's quicker, some states it's longer. If I had to guess, I'd say ours is probably in the middle.
Okay.
But there's some states that it doesn't take anywhere near as long.
That's awesome. Well, I definitely appreciate you hopping on, man. And if you could, I mean, would you want to tell people how they could reach out to you or how they could contact you? I'll put it in the notes too.
Sure. Yeah, I'm easy to reach. I'm at the Crowe Law Office. I'm in Yelm, but like I said, I practice everywhere, and I meet with my clients via phone, Zoom, whatever, so you don't have to make the trek all the way out here to the wilds of eastern Thurston County. My phone number is 360-810-8006, and you can reach me at dan@crowelaw.net as well.
Awesome.
There's an E at the end of Crowe, so it's CROWELAW.net.
Awesome. Well, thank you, sir. I appreciate it, and I'm sure we'll be talking more on some other stuff.
Thanks, Ryan. It's good talking to you.
All right, man. Bye.
Bye.